Everybody. Okay, we are waiting for some people to jump in on the webinar. We also are Facebook Live as well. This webinar is going to be recorded. We are so excited because our TAP Talks have really taken off. TAP Talks is a way of us sharing information, resources from the Triangle Aphasia Project. And I had hopes that I could get the folks from this amazing law firm to join us. We have had such a wonderful relationship with Jackie Bedard and her law firm, which is called Carolina Family Estate Planning. I always look down to make sure I get exactly right. And I will tell you all just a brief story, is that when my mom first had her stroke, and there was a lot of confusion, how to know, she was getting bills, and I had to figure out Medicare, and I had to figure out her secondary insurance and all of the things. And I just kept paying the bills. So I'd borrow money from her IRA, not knowing that there's a penalty for doing that, just making all kinds of decisions that I just really wasn't educated to make. And one day we found Jackie Bedard, and we went in. My mom, she was wonderful, supportive in terms of helping my mom make decisions. And she kind of really stopped everything and said, okay, let's look at what we need, and really helped us figure out not just the finances, but the legalities and the rights, the communicative rights, the living rights that she had. And so all of the money my parents had saved for retirement, didn't get to go to, all the countries they wanted to go visit, but it did help care for her. And things are so expensive, as we know. There's so many questions. So we offered an opportunity to have that with our own family. And we put together our living wills and our proxies and everything that now we feel very secure about in our own family. More than that, we had Carolina Family Estate Planning to TAP a few years ago, and it was a very popular TAP Talk because there was a lot of questions about, my significant other and I are not married, and so what do I do about this? And my wife might have to go to assisted living, and do we have to claim now that we have no money? How do we do all of this stuff? And I just think this is an incredible resource that we have right here. And just recently, they've added a component to their programming besides like books and resources that she's going to tell us about, but also some specific programming for dementia. So I just want to say that just personally, I'm so grateful for this law firm and what they bring to this community. And I'm really excited to meet and introduce you guys to Abby Hudson, who is an estate planning attorney at this Carolina Family Estate Planning. Welcome, Abby. You're muted, hon.
Hi, thank you so much. I'm so excited to be here this evening and meet with you guys. We're going to have a great evening.
That's great. So Abby has, I think you've put together a presentation that you're going to share with us. We are taking questions. So we are on Facebook Live. You can drop a question there. I'll be monitoring that. We also have right below you there Q&A and chat. You can put a question in there, a thought, and we've saved some time, right, Abby?
Yes.
Do you want to tell us a little bit about yourself before you share your presentation and get started?
Yes, of course. So hi, everyone. My name is Abby Hudson. I'm an associate attorney at Carolina Family Estate Planning. I actually have been working with Jackie and our firm since January of 2020. I started off as a law clerk, and I graduated from law school last year and passed the bar. So I resumed my term at Carolina Family Estate Planning, starting as an attorney this past September. It's been fantastic being able to work with the Cary community and our clients. I love it, and I'm so excited to meet with you guys this evening and share a little bit about what we put together with our PowerPoint presentation.
Awesome. Thank you, Abby. And before we went live, we were talking a little bit about aphasia. I think it was semi-new to you, right?
Yes.
as we've learned, it's new to many, many people. About 85% of people have never heard the word aphasia. Maybe the situation recently with Bruce Willis has helped bring awareness to the term, but we know if you've seen one person with aphasia, you've seen one person with aphasia. It's very different, and it affects all the people around the individual. So the family, the friends, the community. And I think this is really so encompassing. I have told Abby a little bit about aphasia. I told her that that she needs to talk a little slow so that we make sure that we catch everything, but that we will ask questions. So if you guys need any clarification, let me know. And okay, it's all yours. Do you want to share your PowerPoint there?
I sure will. Let me go ahead and do that. Okay, perfect. So hi guys, welcome. My name is Abby. Again, I'm one of the attorneys at Carolina Family Estate Planning. And today I'm going to be discussing 3 secrets to protect your family without going broke or being a burden. So today, this evening, what you'll discover is how to make your wishes clearly known and make things easier for your family. We'll talk about some of the tools our firm puts together that can help make things super clear. We're also going to discuss the quote unquote power tools that you need to avoid leaving your family dealing with unnecessary roadblocks and bureaucracy. We'll get into that, and also some common mistakes when creating a plan. Just want to make sure we're weathering any potential storms in the future. So this seminar is going to be great. This seminar is for you if you're sick and tired of worrying about protecting yourself or your loved ones and you want answers. Maybe you're confused by conflicting advice you've been given over the years by friends, other attorneys, CPAs, whomever. Hopefully we can clear everything up tonight. So imagine if you could wave a magic wand, so to speak, and get a clear plan for your future with no mess for your spouse or your children, whomever your loved ones are that you are leaving when you pass. I just want to make sure you and your spouse and your loved ones have enough income and assets to last the rest of your life. We also want to make sure you have a plan for care so you don't have to worry about being a burden or losing what you've worked so far for. Also, we always want to prevent any conflict going forward. So my goal today is just to start introducing to you some of the protections that planning can provide. I'm not going to talk in a lot of legalese. Want to make sure that this is clear and this is efficient. So first, to start off, I want to give you a little bit of background about our founder, Jackie Bedard. So Jackie has witnessed the elder care journey and what it's like going through such journey from her step-grandmother who had Alzheimer's disease and grandfather's experience with vascular dementia. This family experience really instilled in her the importance of planning, having a plan in place, and making sure you have a team of elder care professionals, and we'll get into that later. Also, a little background on Jackie. These are her grandparents right here, and also an inside look with her husband, Dan, and her fur babies right here. So a little bit about me. Again, I'm an attorney at Carolina Family Estate Planning. I first joined as a law clerk in January of 2020. And then last year, I became an attorney, passed the bar exam, graduated law school in September of 2021. So I love my hometown of Greenville, North Carolina, just about an hour and a half away. I frequently go home to visit family and friends and love doing so. So the very first thing I want to talk about is what you need to know about protecting yourself and your family, and one important thing that we need to do for your plan to work. So again, I want this to be a clear process. I don't want to speak in any legalese. I really just want to make sure we're breaking this down and having a great interactive conversation. So to start with, the first thing we like to talk about is putting your own oxygen mask on to make things easy. So you know when you go on a flight, before you even take off, you have the lovely stewardess up at the front talking about emergency help and tools. And one of those emergency tools is going to be that mask to receive air. They always tell you to adjust and put on that mask for yourself before you help others. So that's one of the analogies they give. While that's important in traveling, it's actually also important when it comes to estate planning. We want you to first have an estate plan in place for yourself that is comprehensive, and in helping yourself, you're actually going to make it easier for your loved ones, for your spouse, those who are assisting you going forward. So a lot of people think planning is just about protecting their loved ones, but again, one of the most important things you can do is protecting and caring for yourself first and making that path easier for them. So one thing we want to do in creating this comprehensive plan is we want to avoid unnecessary red tape, bureaucracy, and roadblocks. Now, what are some of those roadblocks? Well, some of those roadblocks can be impediments for making decisions with healthcare providers, banks, financial institutions, and even any conflict with other family members and how certain decisions should be made. So one thing, this first bullet, I'll give an example, is the HIPAA silent treatment. So we want to make sure that in making medical decisions, if you are incapacitated and someone is making decisions for you, one thing you'll need is a document to be able to override this HIPAA privacy and be able to obtain and learn about medical information that pertains to you, so they can receive that information in order to make medical decisions. We'll go over some of these documents that are important to do that. So first, what I want to talk about is your healthcare power of attorney document. So one thing that we highly recommend and that we provide with all of our plans is a power of attorney package set. And that is comprised of a durable power of attorney, a healthcare power of attorney, and then also a HIPAA authorization. So the durable power of attorney is the financial world, but let's also look at the medical world with your healthcare power of attorney and the HIPAA authorization. So these documents, what they do is allow an agent to step into your shoes, an agent that you've named. So maybe a spouse or a family member, they're going to be able to make financial decisions for you, manage financial assets, so maybe a bank account, a vehicle. In the event that you're incapacitated, you can't make decisions or manage financial assets. Switching gears out of the financial world, the healthcare world has a healthcare power of attorney document that allows the agent that you yourself named to make medical decisions for you. And then we talked about this HIPAA authorization, and we just talked about in our other slide, this HIPAA authorization. That allows individuals named to receive medical information about you on your behalf. So that goes in tandem with the healthcare power of attorney. The healthcare power of attorney gives decision-making authority, and the HIPAA authorization gives authority to receive medical information. So those documents are very important to put in place, and they're very important because if you do not have those within your estate plan, if you become incapacitated and someone needs to make decisions, whether financial, whether medical, we're going to need to go through something called an adult guardianship proceeding. And now we want to avoid a guardianship proceeding if we can, because it can be time consuming. It can take 3 to 6 months to have a guardian appointed for you on your behalf, and that guardian would be making decisions. We don't want this because legal fees are going to be incurred. Those are unavoidable. This is going to be a court process, so we have legal fees. Also, we want to prevent a judge appointing someone that you may not want to be first in line, the first individual to make decisions. So we want to put the power in your hands through a power of attorney package to nominate your agents and individuals who would make decisions for you. So one common pattern theme we see is some people don't think they need to do or execute these power of attorney documents because they just say, my spouse will take care of it. My spouse will step in. And while that may be the case that your spouse could be appointed for you during that guardianship proceeding, I do want to note that the law doesn't assume that you like your spouse or you want your spouse to manage your assets. So that guardianship proceeding, they're going to be analyzing and looking into who would be the best fit, and the spouse might not automatically come into play. So inadequate healthcare planning. So we just want to make sure, using these power of attorney documents, that we are alleviating any family struggles with making decisions, any conflict on what types of decisions should be made. So in addition to your power of attorney package, now I also want to include another thing we include, which is called a personal planning portfolio. These contain personal planning worksheets. So you may be saying, what are these worksheets and how do they help my family make medical decisions for me? So your personal planning worksheets are going to be an umbrella term for documents that we provide you, namely a living will, a letter of guidance to your healthcare agent, a personal care plan, and final arrangements. So 4 different worksheets are included in this personal planning portfolio and these personal planning worksheets. So what these documents do is they list a variety of medical scenarios. So for example, specifically your living will could have, if you're in a coma, if you have some sort of brain cognitive defect where you're in a coma, things of that nature. What would you like? What medical preferences do you have? Artificial nutrition, hydration, things of that nature. They're pretty hard scenarios. I know those can be overwhelming, but taking advantage of a living will and listing your preferences can serve as an illuminating guide for your healthcare agents. They will be using and looking to that living will and those other worksheets in making decisions for you. One thing I did also want to touch on right here is we have a program for clients who experience Alzheimer's or dementia. Maybe it's early onset and you want to plan for that. We do have organizational tools that we will break down even further your wishes for medical scenarios, even day-to-day scenarios. So activities, recreational, family visits, things of that nature for your daily activities. We can even get that specific in listing what you would like someone to assist you with and your wishes there. We will also meet with you to take down your goals, take down detailed notes so we can always look back and review and make sure your estate plan is aligning with these goals. Another thing we do is we have a financial advisor and also our lead attorney, Kelly Corbett, and our founder, Jackie Bedard, are well-versed in elder care planning and taking advantage of different resources to preserve assets, maybe take advantage of Medicaid planning, things of that nature, and that's strategies that we can help you out with and how to plan for the future if you are suffering from Alzheimer's or dementia. Now, getting a little ahead of myself, we want to make sure we are arming your family with a Swiss Army knife instead of a butter knife, so to speak. So providing tools to your family to be able to make decisions for you is a wonderful thing to do. And again, we can do that through your power of attorney package. That's the legal substantive documents on listing people that you want to make either financial or medical decisions. And they work conjointly with the personal planning worksheets. And those worksheets gives insights and guidance on your wishes and your preferences as your agents make decisions. So those are very important to have in place. So we want to make sure you have a powerful power of attorney. You don't want it to be a basic power of attorney, whether that's a durable power of attorney, the financial side, or the healthcare power of attorney, the medical side. So that's one thing we can help you out with. We always say we want you to have a powerful power of attorney, not a basic or general. Moving to step 2, we want to talk about how to avoid probate while also saving time, money, and hassles. So we want to talk about what you need to know to protect your family and why almost everyone is wrong about the importance of a will. So let's get into this. So frequently we have clients come in and say that they just need a simple will, and that's all they need is that one document, that will document, and that's all they're really interested in. So we want you to be wary of just creating a simple will, because we want you to have a comprehensive estate plan. And I keep throwing around that term, estate plan. What the estate plan is going to mean is your will, but also your power of attorney documents, also your personal planning worksheets, and other documents that are important to how your estate and how your affairs while you're alive should be handled. So just want to make sure we want to include several documents, not just a simple will. So just a little information about a will, and why some people don't like the will route is because a will is a one-way ticket to probate court, so to speak. So what is the probate court? Well, the probate court is a court administration process of where we will file your will, and the court will essentially review and check off certain action items before assets can be distributed to your beneficiaries, to your loved ones. So a will basically just says, hey, this is how I want my assets distributed. And it's kind of telling the probate court that. So a lot of people don't like the probate court because it can be time consuming. It can take anywhere from 9 to 18 months. And currently, I would say the general rule of thumb is 12 to 18 months for that probate process to be completed. So it is time consuming, may be expensive. You know, there's going to be court fees, there's going to be legal fees. Also, if you want to hire a law firm to help assist you with filing proper paperwork with the court and gathering all the information, there's going to be fees incurred. Also, it's going to be public. So you're submitting information to the court, meaning it's going to be of court record, and court record is going to be a public record that others can access and see the information there. So the bottom line is the probate process, it's a lot of times unpopular, and it's more than just a simple process. It is typically a waste of time, money, no privacy, and a lot of resources there. So one thing clients like to take advantage of if they hear probate and they don't want to do probate, they want to have probate avoidance tools in their estate plan. Also, if they want this to be more private and they want more flexibility with controlling how their assets are distributed, they'll do the revocable living trust route. Again, it's very flexible. The client will be the trustee. The trustee is just a funny legal word for you will have power over conducting business on behalf of your trust. You can update your trust going forward. You can remove provisions, add provisions. You have a lot of flexibility there. You have total control and access over everything, kind of what we touched on. You can change that entire document whenever you would like. And one important thing is assets are titled, meaning ownership titles and beneficiary designations for beneficiary designated accounts. Think your retirement plans, think your life insurance policies. They're titled in a way that avoids probate. So one thing is we want to make sure your estate is a treasure chest. So we want to make sure we're protecting your beneficiaries' inheritance after you pass away. We want them to have access to a foolproof treasure chest, so to speak. So for example, we want to make sure that the inheritance that you're leaving to your children has spousal protections, but also bloodline protections. So what do I mean by spousal protections? I mean, we want to make sure that those assets are protected in the event your child, your beneficiary, obtains a divorce. We want to make sure they're protected and that the spouse cannot eat into those assets or be entitled to those. By bloodline protections, I mean, we want to have backups in place for what if your child predeceases you. So no one ever wants to think about that, but we want to have protections so that your children's, your beneficiary share will pass to your grandchildren. those kids' children and have those protections in place there. So those are really important and something we include in our trust plans. So let's talk a little bit about assets and titling these assets if you take advantage of the trust route. So thinking bank accounts, real estate, retirement accounts, investment accounts, all of those things. These assets are important because we help you through the funding process. We help you fund your trust. Now, what does funding mean? What does the funding process entail? Let me give you an analogy. So we like to say your trust is like a box. So in that box, in that trust, we want to put all of your assets. We want your trust box to hold your, checking accounts, your saving accounts. We want it to be a beneficiary designation for retirement plans and annuities and things of that nature. We also want to update any deeds so that real estate is owned by your trust and in that trust box. So we nickname that process of putting all those assets into the box funding. And once all those assets are in your trust box, your actual trust document, that physical document, serves as the rule book or a blueprint on how all those assets in that box should be distributed. So we may have some conditions. We may have spousal and bloodline protections. We want to make sure all those protections, all those rules, so to speak, are being applied to the funds in your assets, real estate, etc. So that's one thing we actually include with our trust plans. We assist you with the funding process. We will not leave you in the dark. We'll help you actually reach out to institutions via letters that we will draft for you, and those letters will help you update ownership on various accounts and also beneficiary designations. So moving into our third point, this is how to live retirement on your own terms without going broke or being a burden. And before I change to the next slide, I do want to let you know, I believe Maura held up some resource books before she introduced me. We do have some resources put together. There we go. Thank you, Maura. We have some wonderful resources put together on how to plan for retirement, long-term care, how this intertwines with dementia and Alzheimer's and planning of that nature. And we actually have ebook sources. So Maura has a physical copy, but we do have ebooks, and I can provide links to those ebooks to her, and we can get you guys' contact information at the end. Make sure we're sending you all the resources so you can see in plain English strategies and other things like that. Moving to the next slide, I may sound like a broken record, but I do want to emphasize we want a written comprehensive plan listing care preferences. So what do you want to happen medical scenario wise or otherwise if you become incapacitated, also after you pass away, who's doing what? We want to put people in certain roles. So we have the agents we talked about earlier, but we also have something called successor trustees. If you have a trust plan, those individuals will step up when you pass away to make sure everything is distributed under that trust document. Or your executor, if you go the will route, the executor will be the person to step up and make sure that probate process is completed and assets are distributed to your beneficiaries. Also, we want to make a plan for paying for your health care and extended care needs. That's something we can work with you to strategize about how to, strategize your bank accounts and money, long-term care insurance, things of that nature, and utilize a wide variety of resources to plan for the future. So we have some clients that tell us, we're never going to a nursing home. That's never going to happen. So we don't need to plan for it. But long-term care doesn't always mean a nursing home. That could be in-home care and assistance. We can help you strategize on how to pay for that and what should our game plan be. It can also mean living in a senior community and you're very independent, but you live in one of those communities and have individuals be able to assist you there. So we just want to make sure that a part of your planning is a long-term care plan. Just want to make sure we're planning, putting a financial plan into play for any extended care needs. We want to make sure we have a combination of tools and strategies. When done properly, a long-term care plan should include strategies that captures for your wishes. Maybe that's healthcare, maybe that's financial wishes. Also arranges for how things should be arranged and paid for. So one thing being, maybe you're thinking about final arrangements, meaning burial or memorial instructions. And I use the term final arrangements because I want to loop back to those personal planning worksheets. We do include a final arrangements worksheet that can list memorial or burial instructions and list out insight on there on what you would like your family to do pertaining to memorial type things. Also, what I want to talk about is how helpful advice could backfire. Just want to make sure you have a elder care professionals team. So we get a lot of he said, she said about what to do with assets planning for long-term care, what to do for assets planning for if you're incapacitated, and even when you pass away. We get a lot of he said, she said. And I always want to emphasize you need a team around you, meaning an elder care, an elder law attorney, financial advisors, and professionals of that nature, just to make sure you are well equipped. Medical professionals also included, because having a complete estate plan is going to take legal, tax, and financial professionals working together in a cohesive way to put together your estate plan and your estate plan strategies and resources. So one thing I want to note is, we can be a part of that elder care professionals team. Our founder, Jackie, has years of experience with this. And our lead attorney, Kelly Corbett, also has years of experience. And we will be happy to work together with you to go through strategies, go through our resources, and help you get documents in place, those worksheets in place, and things of that nature. And bonus tip, this may be that one most important thing that we were talking about at the very beginning. Don't procrastinate. We have clients coming to us where they've experienced being their parents, executor, or trustee, whatever the case may be. Maybe it's a headache, maybe things took a turn for the worst, and they wish they had a more extensive or comprehensive plan. And that's why they come to us, because they don't want to procrastinate. Maybe mom and dad did, but we don't want to procrastinate, and they want to leave it easier for their kids, the people coming after them. So bonus tip, don't procrastinate, reach out to us. We have plenty of resources. We're happy to meet with you and get you on the right track, depending on what you're interested in. Also, we have those resources. I want to open up the floor now to answer questions as well. And Mara, have we had some questions coming in through the grapevine?
Well, I have questions. So while we wait for some other questions, I'm going to stop here sharing so that we can see each other. And wow, that was a lot of information. And I know as you all are listening that your mind is going, well, what about this and what about this? So I'm going to start with a couple things that hit me right from the beginning. And hopefully they're things that you all have been thinking of as well. I remember when we were going to go and talk to Jackie about my mom's situation. And I laughed and said, we don't have an estate. And I think I'd really love if you could kind of clarify that, because it was a big, it was almost a deterrent for me thinking, well, I mean, when people have estate sales, it means they had a real, like they had a mansion on a, you know, 1 million acres or something. And I think that really needs to be clarified for people, because an estate doesn't mean that you are wealthy and have this giant thing. Do you understand what I mean?
Yes. So estate and also estate plan. I have clients come to me and say, I don't have an estate, or I don't have an estate plan. I have a will, or I have a trust. That's what we're talking about. Right. And this is great opportunity to clarify this. So your estate is going to be the assets you own currently. That's going to be what you own when you pass away. So estate can be cars, homes, real estate, cash accounts, retirement accounts. Any assets, all those assets you own is going to be your estate. And I think the commonly thought of thing is an estate is going to be $11 million worth of assets. Right. It doesn't have to be that big. It's whatever is specific to you. So whatever you own. And then switching gears to an estate plan. I use that word a lot. So Mara, I'm so glad you stopped me. An estate plan is just an umbrella term. Think of an umbrella term, and your estate includes your power of attorney documents, but also a will or a trust. So it depends on what route you take, but it's a will or a trust and those power of attorney documents. Even let's throw in those personal planning worksheets, because this is an umbrella term and encompasses all of your tools to help distribute your assets when you pass away, but also manage your assets if you are incapacitated. So yes, so if you hear estate plan, it is an umbrella term. And I use that because it's a generic term. I don't know if you have a will or you have a trust. Not sure what we're working with, so I use that as an umbrella term. And I also want to make sure that includes power of attorney documents, because we talked about how these work in tandem all together.
That's an excellent clarification. And I mean, even what happens to people that don't have any of these things? Yes. So exactly. I mean, I think that when you think estate, like we've already kind of demystified that just means what you have. You know, it might not be a whole lot, but it's yours and you need to protect it, right? Right. So if someone doesn't have it, are they not protected? And what could potentially happen if people don't have these kind of things in place?
Right. So first, let's start off with the power of attorney side. So we talked about the durable power of attorney and the healthcare power of attorney. Those documents help agents that you elect make financial and healthcare decisions. Those are those two main documents. Also, I always want to include that HIPAA authorization, allowing people that you name to hear of medical information. So the power of attorney documents are important because you get to elect who can make decisions. That's your choice. If you don't have these, there will need to be a guardianship proceeding. Now that's going to be costly court fees because it is a court process. Also, you run the risk of your first choice may not be appointed. So a judge is going to oversee this. We're going to have attorneys involved. And what if someone is appointed that may not be your first choice? We always want to give the power to you and you choosing who makes decisions for you and how things happen after you pass away. I also want to loop back into emphasizing those personal planning worksheets that lists your wishes. So not only are you listing in the substantive, legal, durable, and healthcare power of attorney document who you want your agents to be authorized to make decisions, but also in those worksheets, you're giving an inside look on how you would like them to make decisions regarding your personal care. So we just want to be specific and put the power in your hands. Switching gears here, what if you don't have a will? What if you don't have a trust? So these come into play after you pass away. I want to make the distinction that those power of attorney documents come into play while you're living, but you're incapacitated. Once you're no longer living, once you pass away, the power of attorney document world ends. Now we're looking at a will or trust. If you don't have one, you're going to have passed away intestate. That's a funny legalese term to you don't have a will or a trust. You know, legalese likes to have these funny words. In that case, you're going to have one of your family members would need to petition the court to be appointed as administrator of your estate. So going through the process of being appointed administrator, and then there comes in the process of how should your assets be distributed? What if you don't have beneficiary designations or payable on death or transfer on death designations? What if you do, but those folks have passed away? Who's the institution going to look to? So then we have to go through, and your administrator is going to have to work that out. So messy stuff, time consuming, going to incur fees. So we definitely want to plan ahead for those and have something in place, whether that's a will or a trust. I didn't mean to bash the will route, truly didn't. Tons of clients take advantage of those. Really just, we want to see what your goals and needs are, and let's find a route to do that. That may be a will, or that may be a trust. Whatever is needed for you, for your specific situation, is what we help you put into place.
Wow. I think that clarifies so much. And I love how you differentiated what happens while you're living and then what happens after. And let's face it, we don't plan for those things very well. You know, we kind of hide under a rock and go, it's okay. It'll, you know, it'll take care of itself. But as you explained all the fallout, to me, I was getting stressed. Like, it's got to be extremely stressful for the people who are already, especially if you've passed away and you're dealing with all this stuff. It must be very stressful when you're also trying to grieve and, you know, the loss of a loved one. So I so appreciate that. And I keep hearing the same thing over, and this is some of the, you know, the comments too, is it's about you. It's about your decision. You know, who do you want to make the decisions about something that happens for you? If there is somebody who they have not designated you, then sometimes you can't get any of the information.
Right.
So let's go back to that one for a second. You're living, but you've had a stroke. You have aphasia. You can't communicate well. What is potentially going to happen if you don't have this like HIPAA release form, or you don't have, I mean, these tools that you put into this personal plan to me are like, it's just good business to yourself to be able to make sure you have these things. So what could happen if you in the hospital or whatever, if you don't have a power of attorney named, if you don't have these HIPAA forms signed?
Exactly. So one roadblock is going to be the HIPAA privacy laws. So I know we've all had the experience at a primary care physician or other healthcare professionals, but at that primary care physician, you're given a clipboard of documents to sign. One of those is going to be HIPAA privacy, just listing how they are going to protect your medical information, links they take, etc. Signing, and you'll be signing that this was disclosed to you. So that HIPAA authorization is very important, and it's one of our 3 power of attorney package documents. This document helps you essentially bypass those HIPAA privacy laws and allows your healthcare power of attorney agents to be able to receive medical information about you. But also, I frequently see clients not only add individuals who are their agents, those have to be on there, but adding additional individuals. So maybe your sibling who isn't a healthcare power of attorney agent, but you want them to be involved in a scenario like this. So I like to say this is the keep you in the loop document. What if you've had a procedure and there needs to be a status update? Well, a doctor is talking to your healthcare power of attorney agent that you've listed, and in giving that status update, incidentally, medical information has to be disclosed, and medical information is very sensitive. We don't want to bar everyone out the door, who's your family members who you would like to stay in the loop.
Right.
Also, they could serve as emotional support for that person serving as agent. So we'll see adding siblings, maybe adding kids. You're not comfortable with your kids serving as your agent right now. Maybe they're 18, 19, but you're comfortable with them being in the room and assisting. And by assisting, I mean giving emotional support and being able to stay in the loop there. It also feels good to your family members to be able to be included. And if any scenario comes up where they may be barred out the door, hey, we have this HIPAA document. She can stay. This is our daughter. You know, she's teenager, 20s. She's not our agent, but she can hear or learn of medical information that pertains to you. So that HIPAA authorization is very important. Looping back to the guardianship proceeding, if you don't have these documents in place, we're going to open up a guardianship proceeding to be able to appoint a guardian to make medical decisions for you. Now, emergency decisions may follow a different scenario because if there's a life or death situation, the doctor is not just going to refuse to talk to someone, but that's a lot of nuances. So let's leave that emergency situation. Just know that they'll be able to work with someone if there's an emergency, but in not short-term, immediate, urgent action items, just medical decisions as a whole. You need someone to be able to make those. A guardianship proceeding is needed. That's with the court. So there's gonna be legal fees. May take, I think, 3 to 6 or 9 months was on my slide, trying to make sure that's determined. And also the main point of, we want to put into your hands who's going to make the decision. It's not a court, not a judge, not someone else. They might appoint someone who they think is correct, but their thinking isn't yours. These are your agents. We want people you choose to make those decisions and be your agent.
And it seems like so much common sense to kind of make those decisions before you need to, you know, before you have to. I remember Jackie mentioning even that we have adult children. So as they turned 18, if they were to, God forbid, have something happen to them, that we may not be able to make decisions for them because without them saying, you know, this is who I'm saying is okay to make the decisions.
Exactly.
And to respect their rights. So I can't come in and say, you know, I want this done with him or that, if they put those in writing. We have a couple good questions too. One of our listeners said that they're a durable power of attorney and healthcare power of attorney for their best friend who had a stroke a little over a year ago. The question is, how can they encourage their friend to get a will or a trust? Listening to this, I think, is motivating people.
Right, exactly. So serving as an encouragement, one thing I've heard some of my team members use, because we're estate planning professionals. So when we have loved ones, we want to kind of urge them to do it, is we kind of say, you know, I wouldn't be a great friend if I didn't encourage you to have a will or a trust in place. So that's how you can start the conversation up. I care about you so much, and I want to talk about making sure everything goes smoothly in the terrible event you pass away. Now, no one wants to think about that. No one wants to think about that. One thing that is a big hit is we want to make sure we make it easier for those who come behind us. So your children or whomever may serve as your executor if you have a will, or your successor trustee if you have a trust. Just want to make sure we are making it easier for them and less time consuming, less fees, etc. And also just want to make sure we get their inheritance, those assets to them with as little roadblocks as possible. And that's usually the kicker, bringing in, making it easier for those that come after you.
You're protecting them from having a mess come after them.
Yeah.
And there's a second part to that question, but I want to add from an aphasia standpoint is that the person that has aphasia is competent, cognitively does not have intellectual or memory impairment unless they have a progressive disease similar to FTD or PPA, primary progressive aphasia. But if they have had a stroke and they have aphasia, they should be intimately involved in these discussions. Maybe these discussions didn't happen before they had their stroke, but if they're going to happen now, we need communication supports to be with them. And that's one thing that TAP can help you all with, your families that are out there, is there are pictographs, support papers that, can be provided. I know that we've given Jackie some to do when she has a conversation with somebody with aphasia to make sure the decisions that they're expressing are what they actually mean. We all know with aphasia, you can say he instead of she, and then you've said their aunt's name and you meant your sister's name. We got to make sure that there is no question. So I want to make sure that you all know that it's important, and you can access those professionals here at TAP to help you provide communication supports. Tell me about, one of the other questions is about, can anyone contest a trust or a will? And if somebody has been provided with that power to help make decisions and somebody else isn't happy about it, whether it be a family member or a friend, what happens there?
Yes, so love this question. We actually include a contest provision in all of our will and all of our trust plans. And that contest provision, we want it to serve as a deterrence effect, because what it includes in there is if a beneficiary ever tries to invalidate your will or your trust, and by invalidating, I mean hauling your executor, hauling your successor trustee to court, trying to essentially do away with the will document, do away with the trust document. Usually they're trying to do that to get more of a share than what's in that document. That's why they want it gone, because they don't want anyone to look at it. They want 90%, and you've left them 20, 30, 50%.
Right.
That happens, they may potentially forfeit their original share altogether. So if say you have 2 children, you're leaving everything 50-50. That child may potentially forfeit that 50% share altogether just because they started litigation and they try to get 90% and leave their sibling 10%. So we include that. We don't see that come up. I honestly haven't yet. I haven't heard of that being used yet. But that provision I actually point out to clients in all of our document review meetings, just so, hey, we keep the peace here. One thing I do want to note is with contest provisions, trying to help prevent that. In your trust, we include what's called a trust protector. That individual can hire a neutral third-party mediator to try to settle disputes between beneficiaries and keep it from going to court, keep something from being contested. So those are some backup provisions we have in place, just trying to prevent folks from trying to come along and contest your will or your trust. And we as a firm actually don't do will or trust contest. So my knowledge is a little limited in that, but that's protections you'll receive from our documents that I wanted to go over.
So it's kind of avoiding that ever becoming an issue.
We want it to stop it from ever even budding or spawning, so to speak. So that's what we hope in using these backup provisions.
Thank you. I hope that answered your question. If not, feel free to add another question. If you have questions, you can also drop them in here. I had 2 other things come up. One question was about, and it's more of a statement of protecting what you do have. So I think people get the impression that, well, my loved one is going to have to go in a nursing home and they're going to, now we can't have anything and they're going to spend all of our assets and we have to, and I'm talking about everything like, I'm going to sell my home and I'm going to have to, and I think one of the really educating tools that you all, this is what you're here for. You go to a doctor if there's something wrong with you, you go to an elder care attorney, and this type of practice, a family type practice, when you want to make sure things bad don't happen. So
Right.
I remember with my mom, one of the things that you all really made us think about is, okay, so what about setting aside money for her funeral? I would have never thought of that. But
Right.
if we had not done that, we would not have been able to hold a funeral for her. Setting aside money for even getting her back to Pennsylvania, when she passed, and things that we didn't really think about at all. So I don't know if you could just talk on like how there's all these things that can be protected, and there's a certain amount that doesn't have to necessarily come out of every single thing of like a spend down.
Right, exactly. So this is our asset protection strategies. So again,
Okay.
we want to make sure we are thinking of putting away money for funeral expenses, travel expenses, what have you. Part of doing that is putting money aside, but also maybe thinking about what's called an asset protection trust, and make sure we're keeping assets protected from long-term care cost, and maybe Medicaid look back period if that's something you're interested in taking advantage of. So we do these asset protection trusts, and I don't want to get too far into the weeds.
Sure.
They're
No.
pretty complex, but these asset protection trusts are going to hold certain assets and keep them separate and apart from you, because we need to keep them separate and apart from you, because we don't want anyone to be able to go through you to grab them, cause you to spend them down, or be triggered in the Medicaid look back period. I believe it's a 5-year period. So we're going to allow you to still have access to the funds. We're not cutting you off. Separate and apart is an interesting terminology. I'm just saying I want to preserve your income level for what that looks like for long-term care, nursing home, what have you. We want to preserve what your income level looks like to third parties. We always want you to have access, and we structure access in a certain way to keep it separate and apart. We don't want to cut you off from all of your funds and you only have $5 in a checking account to your name.
Right.
Absolutely not. We just
Right.
want to make sure we strategize how you can access and how we hold and manage those assets using these asset protection strategies. That's something awesome that our lead attorney, Kelly, has been advising and mentoring me about. And Jackie, of course, she mentored Kelly. So just something we take advantage of, and we want to make sure we can explain to you guys and use if needed.
Well, obviously, we could have entire, TAP talks on long-term care and Medicare and Medicaid and all those things. But I think you've brought up the highlights that are so important, and you've offered us resources. These are available, ebooks are available. But the most benefit for us, for our family, and I think that mine personally, but also is an opportunity to meet with you guys. And so can you explain, if somebody is interested in sitting down and doing that, what does that look like?
Right.
And then we'll kind of wrap up.
Okay, perfect. So the first step in the process is a vision meeting. So the vision meeting, you'll meet with one of our team members, and that's just to strategize your goals, get to know you, help you get to know us, and give us a little idea of what you're interested in, maybe what your familial circumstances are, what your healthcare situation is like. We want to know if you have aphasia. We have clients that have been diagnosed with cancer, things of that nature. We want to know your situation, family, medical, and financial as well, just so we can get your goals, your needs. And then from that vision meeting, what we do is we pass the baton off to the attorneys at that point, and the attorneys will strategize a plan and meet with you at what's called a strategy session. So they'll meet with you at the strategy session. They'll have the notes from the vision meeting and go, let's make sure we touch base on your goals one more time. We'll spend the first few minutes doing that to confirm. And then this is what we propose. Also, we can answer some questions go over what's the difference between a will and a trust. If you are on the line there, maybe you know which one you want, and you don't need that discussion. But that's where this strategy session comes into place. And those are the initial meetings. What comes next is a document review meeting and a signing meeting. We'll review the documents with you. The attorney will review those, and then you'll sign in office. I do want to let you know that we give Zoom meeting options for all meetings up until the signing, because North Carolina law makes you have your documents notarized and witnessed by 2 witnesses. And we can't do that over Zoom. It does have to be in office. But up until then, we can accommodate you via Zoom, telephone. Family members can join if you want your daughter, your son, whomever to be kind of support. And we provide that flexibility.
That's awesome. And while we certainly here at TAP are not endorsing any one practice, we are encouraging you to get educated. We, personally, I'm just so grateful for everything that you all share at Carolina Family Estate Planning, and the knowledge and the resources that are available on your website and from ebooks and stuff. Get educated about this and plan ahead. I can't emphasize enough the big points of this presentation, which will be available for recording and giving to our TAP clients. But you make the decision. You have the discussion. I'm looking at all of the yous I wrote on my notes here. That it is important that your voice is heard. And I think it's essential that we look at communicative access and communicative rights. And so we'll be including some other tools, references, some things that I've shared with you all before on from the communicationfirst.org, which is an amazing nonprofit organization that has a whole toolkit to make sure that the person with aphasia's voice is heard. And so just get educated, get these resources, find out about them, and take it in your own hands before someone else takes it out of yours. So I just want to thank you so much, Abby. It was so wonderful. I love how you just spent the time in talking about some of these and breaking it down. I think it normalized it and took it to a level where we realized everyone has an estate. Everyone has stuff and wishes that they want. And we could not have done that without you. Is there anything you'd like to say in closing?
Yes, I just want to thank you so much for having me. This has been a fantastic experience, and please have me back in the future. That would be fantastic. But I love being able to speak on this about you. I'm really passionate about estate planning. So thank you so, so much.
Well, we're getting thank yous from everybody and appreciation. We will release the recording, and you will get me the ebook link, and I can get it to folks that request it from me. So
Yes.
just send me an email at mara@aphasiaproject.org. And, thank you again, Abby. We will definitely have you back. And we also look forward to teaching you and more people at your practice about aphasia and helping them access their wishes, because every voice should be heard, right?
Yes, that's fantastic.
Okay.
Thank you so much. I hope you have I hope everyone has a great evening.
Me too. Good night, everybody. We'll talk to you soon.